Hello. In this clip from our Justia webinar, Confronting Racial Bias in Jury Selection, Angie Setzer shares her final takeaways and recommendations about how to eliminate racial bias in jury selection and the legal process. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Number one, commit to fully representative jury pools. To ensure that people of color are fully represented in the source pools from which our juries are selected. We can use multiple source lists, so beyond voter registration lists and driver's ID and state ID lists. States are actually using other kinds of lists, and we can do that as well. Tribal identification lists, tax filing lists, child support lists, public utility records are being used in Nevada. There are lots of ways to increase the source list, which will increase the representativeness of the initial master jury list. Ensure that jurors are summoned actually appear in court. So make sure that people actually get there. There are actually some pretty straightforward and cost-effective ways to do this. Number one, regularly submit names to the USPS change of address database. A recent 2022 report from the National Center for State Courts showed that using change of address database resulted in updating about 10% of the addresses in the jury source list. So that's a really easy way to do something. Also, just renew the source data, update your master jury list. Other options include targeted zip code mailings. So when you get a summons back that's undeliverable, send a replacement summons to that same unit or same zip code. Same thing for weighted summons. Here's a way that you can use geography as a proxy for race or ethnicity. Divide the jury area into smaller units or geographic groups, and then require proportional representation from each of those units. There are lots of sort of straightforward ways to make sure that that initial jury pool is representative. Okay, so what else can we do? Remove procedural barriers to review of claims of racial bias in jury selection. I touched upon this earlier, but in state court, the general rule is that there has to be a contemporaneous objection in order for an appellate court to review a claim of racial bias during jury selection. Some states actually permit appellate courts to review Batson claims even if not preserved at trial. And some states review Batson claims even if they're raised for the first time in post-conviction litigation. Federal and state courts can and should be required to remove barriers so that they are able to review on the merits any claim of illegal discrimination during jury selection, even if the claim was not properly preserved below. All right, third, create accountability for decision makers who engage in racially discriminatory jury selection. So, like I said, even when a court has found that a prosecutor has engaged in discriminatory jury selection, the prosecutor rarely suffers any consequence. States and Congress could create a private right of action for legally excluded jurors. Federal courts have really created these procedural barriers, which protects prosecutors from federal lawsuits and shields them from financial liability. But Congress can and should consider reassessing the doctrines of immunity for state officials and remove procedural barriers by federal courts. Okay, peremptory strikes. So reforming the use of peremptory strikes. Echoing Justice Marshall's concern that the Batson three-step process would not eliminate what's going on in terms of racial bias during jury selection, Arizona actually in 2021 eliminated the use entirely of peremptory strikes in civil and criminal trials. But other states are, sort of doing similar things. California, Washington, Connecticut, New Jersey. Washington actually adopted this rule in 2018, which designates a list of presumptively invalid reasons given by a prosecutor. And those are reasons that have historically been used as pretext for removing people based on race. So these reasons, law enforcement or living in a high crime neighborhood, all of these are presumptively invalid reasons. Connecticut and New Jersey have used a similar list of presumptively invalid reasons. They also have eliminated Batson's first step and the requirement that the proponent prove intentional discrimination. And instead, in Connecticut and New Jersey, they are using more of an objective observer standard or a reasonable, fully informed person standard, meaning that if that person were to believe that based on the information available that the prosecutor engaged in discriminatory conduct, then the Batson challenge would be granted or the strike would be denied. California has done something similar where they've, created this list of presumptively invalid reasons. Other states have done, have engaged in similar sort of reforms, have established judicial conferences to look at this and are really trying to figure out how to eliminate racial bias in jury selection. Next. So when faced with clear evidence of racial bias, courts should adopt a meaningful presumption of discrimination and the practice of using absolute disparity so that you can actually use an analysis that accurately reflects the harm that is done to a defendant's chance of drawing a representative jury. Judges should be required to intervene, even in the absence of an objection. And in some situations, a prosecutor's history of discriminatory conduct should trigger more scrutiny by trial and appellate courts. Other state and federal courts have commissioned studies on proposed reforms, and other states are doing other things. So California in 2020 adopted the Racial Justice Act, which makes it illegal for any state actor to obtain a conviction or sentence on the basis of race, which includes racially discriminatory jury selection or racially discriminatory language. So there are lots of ways we can sort of address this issue. And other jurisdictions are considering and implementing other reforms to the jury selection process. I would encourage you to visit our website at eji.org for updates and ongoing developments in the criminal legal system. And I appreciate your time today. Thank you for tuning in to this presentation on confronting racial bias in the jury selection system.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.